this order. That is maintainable. That is maintainable. Against the only single judge's order means the main judgment as well as the review order both are maintainable. If it is review petition, yes. No, that is true. But now whether he is notified, whether this person, party in person, whether the phone number is available, court officer, you can call him and you can intimate with it. Yes. Pass over, it is there. Yes. It pass over with the court officer on tomorrow. Yes. Yes. None appears for the appellant. This is a matter on 8th February. Yes, Saravana. 23, yes, Saravana. Yes, Mr. Saravana. Yes, Saravana. Mr. Saravana. Recalling the order dated 19/7/2021. Whether the office objections are cured, non-complaint. Office objections are not completed. They are complained with office objections. Even on the last occasion, hearing on 27/1/2022, the matter was passed over in the first round at the request of the learned counsel appearing for the appellants. However, there was no representation in the second round, hence the matter was directed to be listed next week. Accordingly, the matter has been listed today. In the first round, learned counsel appearing for the appellant sought for a passover. The matter is called in the second round, but there is no representation. This court has no other option except to dismiss 2021 for non-prosecution ordered accordingly. It's called the next case. Mr. Ganga Hanamaya.
Yes, Nayak. Ganga Hanamaya, party. Yes, Nayak. 58.
Then appears matter in the second week of March.
But in 29, I am appearing for respondents.
Yes,
I am appearing for all the respondents.
yes, sir. These affidavits application non-compliance of the order dated 26/7/2021, 17/8/2021, and 28/9. Complaint with the office.
None of them have been complied. None of them have been complied.
It will be explained.
Yes.
The affidavit will be explained.
Whether the affidavit copies are served on the other side. Yes. It's a matter on the book. No, we cannot pass over the matter. We don't have any other matter, no.
If permitted, I will make a submission to assist the court.
No, learned AGI is before the court. Let him. Yes. Sir.
Is challenging the order dated 16 March 2018. The respondents will need to be utilized of consider the representation. I got to come to page number 69.
Yes.
I come before the court seeking direction. The respondent authorities to make full authority of catered recruitment rules of Karnataka service rules covering the service of petitioner in any one of those rules from the date of the judicial appointment and make them as permanent employees from the date of their appointment. Further direct them to keep all facilities and given to the government. Which of writ of kindness are any then it's single judge. Page 45.
Yes.
Paying a legal salary and extracting that violation of Article 1920 of the Constitution. Under circumstances, it is fair. Consider the representation. It is not get those representation. In that view of the matter, in addition to the representations made, these are sections C, D, E, and F. Petitioners are also permitted to make one more representation to the respondents within a period of 2 weeks, by providing two particulars. After receiving the authority shall consider the same task within a period of 6 months from the date of receipt of the that they are working in different capacities. These occupation is as to which category of the government department they fall. Classified to C doctor, assistant, gatekeeper, watchman, sweeper, etc. The category they fall and pay has to be fixed. After classifying the category, decision has to be taken with respondent on the fixed pay on part of the permanent employee. It is a mandate of the Provisions of Article 19 of the Constitution that persons who discharge similar work should be paid similar pay on the basis of equal pay for equal work. On the said principle, classification has to be made, and the respondents want the petition takes up for payment. On exact as per which category they fall, and to extend the pay and other benefits along the period. The said exercise should be made within 3 months. Action taken in this regard should be communicated. Further, it is made clear that payment of pay and arrears as directed above. The randomness was sought for framing of rules. But in the writ of peace, the grounds taken are same the rules of framework.
Not only framing of the rules, they have sought for their appointment as permanent employees from the date of their appointment and further direct them to give all facilities which are given to the government employees.
But there is one authority, if I ought to say equivalent number one, it's an independent authority. Authority of Karnataka. It's an independent autonomous authority. Rules are there. If I take Affidavit, when the act was taken up before this court, this report was filed. I take my lot to the status report. 15/3/2020.
Today,
Status report along with the assessment.
yes,
From that status report, I require 2 minutes. It is submitted that as on the date 53 petitioner respondents have been paid additional amount. Additional income 10% year on year, risk allowance, night duty allowance, PF and DSA along with daily wages. A list of detailed payments made during January 2021 to all petitioners enclosed as annexed to this status report. Depending upon the number of years of service, petitioners have been classified at grade 1, grade 2, grade 3, grade 4. Yes, sir. Fact prepared by a current state indicating the post held by the respondent is enclosed as R. Pursuant to the disposal of the petition on 2/2018, Zoo Authority of Karnataka, header recruitment rules to 21/2003. Set header and recruitment rules provides for maximum limit of 35 years insofar as general merit is concerned, 38 years for OBC, and 40 years for scheduled caste and scheduled tribe. However, as one-time measure insofar as petitioners are concerned, age relaxation of 10 years of working and service weightage of 1 year of service, subject to maximum of 10 months has been in the interest of the persons who are presently the cater and recruitment is 398 section posts have been approved as sanction post the state government. 161 is sanctioned by state government. These respondents are all the outsourcing agency wages agreed to in terms of the contract along with other benefits are paid from them. The status report was filed. After the status report was filed, I got my family come to the order dated 26/7/2021. The order sheet of this one. From which day the two respondents died, an application for seeking the after that, again for the state and other authorities. He has drawn our attention to the status report filed before this court containing certain documents including Section R. Enunciate the fact that 53 employees have been regularized. This is the concerned authority is directed to file affidavit containing the names of 53 employees who have been regularized and also to indicate as to how many of the petitions have been regularized. This was the order last minute. The status report does not indicate anywhere with regard to the regularization has done 53%. It is only showing the category, the amount which was being paid. An affidavit was required to be filed based on this order. An affidavit is filed. Along with that, we have also made an application seeking recalling of this portion of order under these factors.
Why did you find the writ appeal? It was only to consider the representations.
The writ appeal was filed on 2 grounds. One was there wouldn't have been any order so far as asking of any mandamus with regard to equal pay and equal work comparative with government employees. It can't be done is that is the ground which is taken. That the learner wouldn't have passed an order directing us to pay. So far as training of cater and rules that we are supposed to do, we have done it. Because that is the ground on which it is.
No, the directions issued by the judge was to classify the category that they fall. That is one direction. The second direction was to consider their representations.
But so far as pay
Where is equal pay for equal work?
that may not be different.
My lord, para number 4, fifth line from the bottom. To fix pay on par with the permanent employees based on equal pay for equal work.
47.
Uh,
That it starts with similar work should similar pay on the basis of equal pay for equal work. On the said principle, classification has to be made, and the respondents 1 to 3 should take steps of payment. Non-payment of exact pay and extracting more work is unconstitutional and arbitrary. Under these circumstances, it is directed that respondents 1 to 3 should classify these persons as to which category they fall and to extend the pay and other benefits along with arrears. That portion of
My submission is that the prayer was not at all
Certainly,
sought by me.
that portion of
Only that portion.
that portion.
Yes, what you say, sir? Another question, Mr. Joshi, sir.
My lord, after filing this writ appeal, in the meantime, we have also filed a contempt petition in CCC 1557 of 2019. Civil contempt CCC 1557 of 2019.
Yes, sir.
Now, in the meantime, after preliminary hearing of this writ appeal, which was filed in 2018, some submission was sought to be made by the government appellant, stating that many of them have been regularized. Many of the petitioners have been regularized. This was their submission. Only based upon their submission, in the oral argument, this particular order dated 26/7/2021, I will reread that order. 26/7/2021, last 7 lines. My lord has got it?
Yes, sir.
Yes. We have heard the learned AGA appearing for the state
Yes.
and the other authorities. He has drawn our attention to the status report filed before this court containing certain documents, including Annexer R, to enunciate the fact that 53 employees have been regularized. Unfortunately, this is an incorrect statement by the learned AGA. I'm sorry to say this.
Yes.
Their statement, oral statement, referring to status report that they have been regularized. Thereafter, in this circumstance, may I continue to read this?
Yes, kindly read it, sir.
In this circumstance, the concerned authority is directed to file affidavit containing the names of the 53 employees who have been regularized, and also to indicate as to how many of the writ petitioners have been regularized.
Where is Annexer R? Annexer R to the status report.
Annexer R is page number 7, my lord,
Yes.
of the status report.
Where did they state that 53 employees have been regularized?
So they have stated in the orally. That is the reason this honorable court was pleased to pass this order.
No, it is not recorded that it was stated orally. Yes, drawn our attention.
I was
to the
there, I
status
was
report.
present. That is the reason this order came to be passed.
This court containing certain.
They are only containing
Annexer
Ani Mel
R.
Vicharaka, Prani Mel Vicharaka, Prani
Employees
Palaka,
are
like this. There are
regularized.
17 items are there. Different designations are there. The number of employees are there.
Annexer R is something different. It is
Something
nothing to
different.
do with-
Yes. There are,
nothing to do with the 53 employees.
yes. So their submission, they thought that their submission will be taken on a face value and the matter will
Now,
be
what happened to the contempt?
thereafter. Contempt is there. Notice has been issued.
Ah.
Because they have not complied. Till today, they have not complied the order of this honorable court of the learned state.
Whether your grievance is complaints means whether it is consideration for regularization
Yes.
or
fixing the equal pay, equal salary, equal category,
Yes.
and a specific categorization of the classification of the different designations. Thereafter, may I make a small further submission, my lord?
Yes.
Thereafter, on 17/8, order dated 17/8,
Yes, sir.
learned counsel for the respondents has informed this court that the order dated 26/7/2021 has not been complied by the appellant. That means there is a further direction of this honorable court. The coordinate bench of this honorable court was that to file an affidavit. So that was also not complied. Learned government advocate for the appellant is granted a week's time to comply with the aforesaid order list on 31/8. Thereafter, may please to see 29/11/2021.
Yes.
I skip about 5-6 lines. Now time warrants 29/11/2021, my lord.
Yes, sir.
In that, after skipping about 5-6 lines, now time warrants for the state government to regularize the respondents who are working for more than 35 years. In view of the above, appellant number 3 is directed to file an affidavit stating as to within how many months the recruitment process will be initiated to regularize the services of the respondents as per the C&R rules. Post this matter after 3 weeks. Thereafter, 6/1, my lord. This matter came up before my lordships. The learned AGA seeks time to file an affidavit of the respondent number 3 as directed by this court. However, learned counsel appear for the respondents points out that as per the order dated 26/7/2021, a direction was issued to the concerned authority to file an affidavit containing the names of the 53 employees who have been regularized and also to indicate as to how many of the petitions have been regularized. But so far, no such affidavit filed by the concerned authority. Though the learned AGA made an endeavor to contend that an affidavit of the Deputy Director Bannerghatta Biological Park, Bangalore has been filed on 9/8/2021. In our view, the same is not in compliance with the order dated 26/7/2021. Hence, we direct the concerned authority and appellant number 3 to file the respective affidavit as directed by this court on 26/7, 29/11, respectively, is this matter. But even today, yesterday I have received an affidavit of Mr. Harish, who is stated to be Deputy Director. In his affidavit, may please be seen. The learned officer is not touching upon the orders of this honorable court in the original learned single judge order as well as 26/7/2021 order. As may be seen, they go on making the different reasons that there is no financial approval and all these things like this. Now we come to the para number 17, may please be seen. I state para number 17, my lord. I state with great respect that the status report and the documents annexed therein does not in any indicate regarding the regularization of any of the employees, but only indicates the petitioners have been paid additional emoluments, experience allowances, additional increments at 10% per year on year, risk allowance, night duty allowance, PF, ESI, along with this one classification grades. I state that in view of the due authority of this one, which has been come into the force from 5/3/2020, that is a C&R, all the appointments are governed by the said rules, and till date, no process of appointment of regularization is initiated by the authority. Further, I state that due authority C&R rules of 2019 provides for maximum age of 35 insofar as general merit and 38 years for OBC and 40 years for the person belongs to SC/ST tribe. However, as one-time measure insofar as in-service workmen and contract basis are concerned, age relaxation of 10 years of working and service weightage of 1 mark of every completed year of service subject to the maximum so and so is provided. Keeping in view the interest of the persons who are presently working, hence the list of 53 employees working at Banergutta showing their names, age, designation, wages and so on given to them was produced before this unquote for further consideration in accordance with the cadre rules. Now we come to the para number 21, my lord. I further state that till date, neither the Zoo Authority of Karnataka nor the Banerghatta Biological Park has regularized the services of any employees, nor have initiated the process of recruitment as per CNR 2019. Now, if we look into the latest affidavit, my lord, what is the value of the order dated 26/7/2021? Either they have to follow the and obey the order of this honorable court are dated 26/7/2021, or they should come back to this.
Because they are not regularized.
They are not regularized.
The status report I read out doesn't indicate. That is like that you also made an application.
Then you would have filed an application to recall that order.
We have filed it along with the subject.
You have filed.
Like,
We have not received any copy.
it was sent by mail.
It's sent through mail.
I have received only by mail. I have received only affidavit, my lordship.
Both are affidavits. Where is the application for recalling the order? Huh? Huh?
Later on, the statement was also correct. The report did not contain that the declaration was any of the it has appeared in the order stating that we have stated to have regulation. That's why once immediately we find the observation. That will also, so far as the consideration of their representation trust, they will not be any difficulty. But so far as extending trust the benefit, that is equal pay for equal work notes is concerned. Particular observation notes goes against the kind of cases where not though they discharge the except duties as of the government
Now,
employees.
whether this application has been served on the other side, IF for recalling the order.
Is not served one more copy.
Whether this application has been served on
No,
you,
no,
sir?
my lord. My lords, yesterday I have received only this affidavit of Mr. Harish.
It says that IA and the affidavit. I serve one more copy. There is no difficulty.
No, there are two affidavits filed. So one is affidavit along with several, along with the copy of served acknowledgement. The other one is IA along with affidavit plus copy of served acknowledgement. There are two sets.
Only one set, one affidavit I have received, my lord, from the office of the Learned Advocate General Office.
Yes, you kindly serve the other application copy that you want to refer to. Yes,
With permission, may I make a small
Yes.
submission?
yes, sir.
Could I request for the contempt petition also to be tagged along with this, so that both are matters pertaining to the same order?
No, we'll see,
my
sir.
request.
It is
It is my
required. Yes. If this order date 26/7/2021, if it requires to be recalled, then it will have to be analyzed
There is one
merits
part.
of the case on
Yes,
the
ma'am.
merits of
Yes, my
Yes.
lord, I agree. But at the same time, there is a internal page number 17 of the imposed order. Para number 5. The representation to consider the representation of the petitioner for regularization of the services.
Yes,
So,
that
after
they are not agreed. They will consider your representation for regularization of service in
But
accordance
what
with
they have
the-
done, my lord, in this case, what they have done in the status report, what has been observed by, perused by my lordships, they have tried to outcast us, outlist us from eligibility. Because our experience is 25 to 35 years for different people, for 53 members. Now, by restricting the maximum age limit of
As
35,
could be, now, as could be seen now, the main grievance of the state government is considering the case of these respondents that with respect to the extension of pay and other benefits and as well as the arrears. That is the only main grievance here, not for consideration of your request for regularization of service. In paragraph 4, what has been considered by the honorable judge
yes, my lord.
is, yes, that is the only grievance.
The para number 5 is also there.
No,
Consider,
with the five, they are not worried. They are not concerned with 5. That is not the main grievance. They are ready to consider your representations. But the main grievance is with respect to para number 4.
which they don't want to, because in earlier affidavit, may please be perused for a moment. Every time they go on saying that they don't have funds, they are lacking the funds.
Now let us see whether this order requests for recalling as straight. Then we will decide it and then we will proceed it.
Yes, madam. If a copy is served, then I may be permitted to file a, I may be permitted to file a suitable objection if instructed by my clients.
That is AGA has filed. IA 1 of 2022 for the order 26/7/20 the extent reads as under. Next act, we have heard the learned AG so and so. In the circumstances, the concerned authority is directed to file affidavit so and so. Regularize. The counsel for the respondent submits that no copies of the said IA has been furnished to the respondents. And if AJ is directed to furnish the copies of the to enable the learned counsel for the respondents to file if any. This is a matter on 28th February.
Much okay.
Great.
For appellant, my lords, in the matter.
Yes.
My lords, the matter was heard, my lords, by your lordships on the other day. And one of the opinion which was expressed was, my lords, where, my lords, the employee, my lords, if he retires, while under TBS scheme, Lords, in a private aided institution, I'm sorry, Lord, then he'll be entitled for benefit of TBS rules. I'm afraid, Lord, that is not the purport of KCSRs, my Lords. For a moment, if your Lordships kindly take 247A, my Lords, of the KCSRs.
Code officer, KCS, sir.
Two 247A, my Lords, 1.
Yes, sir.
My Lords, 1 reads, in case of persons directly recruited after completing the age of 30 years, in consonance with or pursuant to the rules of recruitment through Karnataka Public Service Commission or other recruiting authorities, there shall be added to their qualifying service a period equal to the difference between the age on their date of birth immediately preceding the date of recruitment and 30 years, subject to maximum of 2 years. Now, my Lords, if Lordships kindly come to Lords, sub-rule, my Lords, 5. Lords, there are 2, 3 also, Lords, that is relevant. But 5, my Lords, why I am trying to say is this. When the government servant ceases to be governed by triple benefit scheme rules and enters government service by recruitment, the provisions of sub-rule 1 may be extended if it is advantageous to the government servant in lieu of the period admissible under Rule 248. Now, my Lords, even if it is considered, what I am trying to say that, my Lords, it is 3 + 2, 5 years, even as per, my Lords, these 2 provisions. But what I'm trying to say is that, my Lords, merely for the reason that, my Lords, I am entitled for the TBS as such, my Lord, it cannot be said that, my Lords, KCSRs only will be applicable and I will not be entitled for TBS rules, my Lords, as I was governed at that time. My Lords, may not be, my Lords, that appropriate, my Lord, is my submission. In so far as my case is concerned, 248, my Lords, as I read, my Lords, provides for 3 years of service. Here, my Lords, 2 years of service. That is totally 5 years of service, my Lords, as contemplated by the KCSS itself. Now, my Lords, learned single judge says it is restricted, my Lords, under 248, I have to seek for. My Lord, that may not be appropriate. My Lords, it is ultimately to be decided by the authority. That's the reason, my Lords, I made a submission on the other day that the matter can be remitted back to the learned single judge, where he can consider, my Lord, these aspects. Or, my Lords, direction can be issued within a time frame, my Lords, to consider my representations, my Lords, about the applicability of TBS rules, my Lords, to my case. Insofar as my case is
applying this sub-rule 5 of rule
in addition to 3 years,
247A.
in addition to 248, that is. 248 provides for 3 years of maximum service. This is in addition to 248. 247A, my Lords.
247A, where do you get? That is in view of the period admissible under Rule 248.
248, 3 years of service maximum.
Correct.
3 + 2 will be 5 years.
Where is 3 + 2?
In addition to
my Lords, for the sake of
there is
my
no
Lords,
any word addition, my lord. There is no any word used in the employed in the.
Where do you get that addition of 2
Yes,
years
my
here?
lord. Yes,
my
my
Lords,
lord.
I would, my Lords, read. My Lord, sorry, I did not make that thing clear. When the government servant ceases to be governed by the triple benefit scheme rules and enters the government service by recruitment, the provisions of sub-rule 1 may be extended if it is advantageous to the government in lieu of the period admissible under Rule 248.
48.
What I am trying to say is that, my Lords, in lieu of, my Lords, if it means that, my Lords, if it is advantageous,
What
in
is
lieu of
sub-rule 1?
I'm extremely
Please,
sorry, my
sub-rule
Lords. I am extremely sorry, my Lords. If your Lordships kindly go take, my Lords, 248. Ultimately, what I tried to say, my Lords, was that it cannot be limited by the learned single judge to say that it should be considered in accordance with Rule 248.
No, first we want to read first we want to
ma'am.
read 247A1.
Please, 247A1.
A1, that is what, that is the
Correct,
specific
correct.
mentioned in 5.
In case, in case of persons directly recruited after completing the age of 30 years, in consonance with or pursuant to the rules of recruitment through Karnataka Public Service Commission or other recruiting authorities, there shall be added to their qualifying service a period equal to the difference between the age on their date of birth immediately preceding the date of direct recruitment and 30 years, subject to a maximum of 2 years. Now, my lords, if I'm, my lords, the age of recruitment is taken into consideration, my lords, actual date of birth is taken into consideration if I have been appointed after 30 years of age. Then, my lords, the qualifying service should be added. My lord, that would be, my lords, equal to the difference between the age on the date of birth immediately preceding the date of recruitment and 30 years. That is, if, my lords, if I cross 30 years, my lords, maximum, my lords, it is 2 years.
2 years.
2 years maximum.
Yes. That
Correct,
is,
my lords.
if it is advantageous to the government servant,
Correct.
in
No.
view of the period admissible under Rule 248,
Correct, my lords.
instead of 248, so
Please.
this 247A could be applied.
Now, my lords, I'll read, my lords, other provisions also. Subrule 2, where a government servant is allowed to count his service for pension in accordance with Rule 219A, together with additional qualifying service under this rule, the portion of military service, my lord, that will not be applicable. The addition to the qualifying service, my lord, Subrule 3, there shall be in terms of completed years and not in terms of months and days. The addition to qualifying service is also admissible to a government servant who had rendered qualifying service of less than 10 years. Then, note Subrule 5. When the government servant ceases to be governed by the triple benefit scheme rules and enters the government service by recruitment, provisions of Subrule 1 may be extended if it is advantageous to the government servant in lieu of the period admissible under Rule 248A. My lords, here, my lords, the provision is, my lords, may be extended if it is advantageous. Now, what I am trying to say is, my lords, merely for the reason that, my lords, I'm entitled, my lords, I joined the government service, my lord, they cannot be limited is, my lords, first submission.
This rule has been substituted with the 15 to 2012.
Please, my lords, I retired, my lords, much earlier.
It is prior to 2012, my lord.
Yes, my lord, I retired much earlier. There is no.
Yes, what was the rule earlier?
Lord, that, my lords, right now I do not have, my lords.
Because Rule 247A substituted for Rules 247A and 247B by notification dated 15 to 2012.
Lords, 247 pertains to lords, member of the bar.
247 is not applicable to this case, my lord.
Not applicable.
This, for this case, my lord,
Why
247A.
you are reading, sir, if it is not applicable?
No, why I try to, my lords, cite is this for, my lords, for this reason. That, my lords, one single judge observes that, my lords, I am entitled for, my lords, benefit under 248. My lords, by virtue of the order of the learned single judge, my lords, who did not, my lords, according to me, with great respects, did not consider the issue of, my lords, application of TBS rules to my case. My lords, has limited, my lords, the consideration, my lords, is the submission. 248, my lords, only reads that if an employee of an educational institution which is recognized by the government gets into government service as a result of either the school being taken over by the government or his securing an appointment according to the rules of recruitment, 1/4 of his service in that institution shall be counted for pension and gratuity subject to the limitation that the period so allowed to be counted shall not exceed 3 years. My lords, 1/4 of service in that institution. Lords, in my case, lords, I worked, lords, in aided institution, lords, from 1968 to 75. But that is 7 years, lords. If it is 1/4 of 7 years,
shall not exceed 3 years. It is very clear. there.
That's what I'm trying to say. My lords, what happens is, my lords, my pension will get reduced.
We'll have to read the provisions.
Correct, sir. That's the reason I'm making a submission that these are the provisions which consider. I cannot be, my lords, asked to, my lords, go into only 248 as directed by the learned single judge. My lord, the learned single judge, what was required on his part, my lords, is that when I raised the issue of, my lords, TBS rules, the first and foremost thing, my lord, there should have been a decision, my lords, applicability of that. There is no consideration. That's the reason, my lords, I'm making a request to, my lords, to send back, my lords.
My lord, we'll have to read the 247A 5 rule, subclass 5 along with the 248, my lord. Subrule 5, my lord. May I make my submission?
Yes.
My lord, subrule 5, my lord. When the government servant ceases to be the government by tribal benefit scheme, this is applicable to the present case, my lord, because he is claiming the tribal benefit scheme, my lord. Rules and enters government service by recruitment.
In fact, my lords, I agree with my learned friend. That's what I'm trying to say.
No,
learned single judge could not have said that I should go under 248.
Let us read the entire.
That is the error of, my lords, according to me, apparent. That's the reason I made a request that the matter should go back. My lords, the learned single should also appreciate my contention about.
First answer our question. This 247(5) which you are reading,
yes,
it has come into existence only from 15 to 2012. How it is applicable to the case on hand? None of this, even 6 are the proviso. All
Correct.
This has come to force only from 2012, which was the provision earlier
Lords,
to this substitution.
I can only say, my lords,
Yes.
it is substituted, my lords. Substituted would
Yes.
mean that it dates back to, my lords, the date of original rules itself.
Now, first of all, let us see what was the
Correct.
original 247 and 247B.
Correct, my lords.
What
My
was the
lords,
247 and
my lord, that,
247B?
my lords, I'm little handicapped, my lords, insofar as that is concerned. My lords, I'll try to secure and place it on record. But still, my submission would be that as it is a case of substitution, my lords, it, my lord, dates back to the date of original rules itself, my lords. It is as good as, my lord, the rule standing from that date.
So, if
It would be the meaning of.
if we consider this rule 5 is applicable, 247(5) is applicable, 247(5), then it is
Then, my lords,
only
in that case, my lord, 2 years.
2 years.
That's what.
Yes.
2 years. That's what.
2 years.
That's what I'm
Only
trying to.
2 years.
My lord, that's what I'm trying to say, my lord. My lords, what happened is learned single judge directed under 248 to be considered.
No,
My
whether
lord, there
2 years is beneficial or 3 years is beneficial
My lord,
to you.
according to me, my lord, 7 years is beneficial, my lord.
No,
I
it
mean,
is
No,
not
no, I'm
entitled.
sorry.
my
I'm
not
sorry.
entitled for.
Now you are relying upon this
No, I'm
247.
not. I read it only for the sake of, my lord, to say that, my lords, learned single judge could not have restricted, my lords, me to go under 248. He should have considered, my lords, other aspects also.
So
Or,
according
my
to
lords, he
you,
should have
yes,
decided the issue.
according to you, 247(a)(5) also would come to your aid.
There is also an
Yes.
additional the application of rules, my lord. If it is to be restricted, that only KCSs are applicable, my lords, then it is 247(a)(5). But, my lords,
Then read
248.
further. If that is applicable, 6 also applies. Then
Lord,
in
6, my lords, is in the case of a member of a bar.
no, provided that member of
6, my lords,
bar-
a member of the bar who is recruited to judicial
That's a
service.
judicial service.
6 applies to member of bar going to judicial service.
Proviso. That the addition of qualifying service under this rule is not admissible to employees governed by triple benefit scheme rules.
It has to be read with the main provision, my lords. Main provision is a member of the bar who is recruited to judicial service.
No, not under this sub rule. It doesn't say under the sub rule.
under this rule. Addition of qualifying service under this rule.
Of 7 years ಆದ್ರೆ less than 3 years ಬರುತ್ತೆ. ಅದಕ್ಕೆ ಇದ್ರಲ್ಲಾದ್ರೆ at least 2
2 years.
My lords, that is only, my lords, according to me, is for sub-rule 6. That ambiguity, my lords, again, my lords, with
But
great
okay.
respect, I would put it, that has to be
But
decided by, my
now,
lords, by the learned single judge.
Now, if you look at this 247A5, it is applicable to you.
Please, my lords.
First, we have to see the old rule. If it is applicable to you,
And-
then you are entitled under 247A5 also.
May make one submission. The
So
contention
whether
which was,
3 years, whether 3 years is beneficial to you or 2 years.
my lords, I am albeit a difficulty, my lords, if this question is asked. My lords, I would
3
only
years.
put you, my case, my lords, my case before the learned single judge was that, my lords, 7 years of service required to be considered.
No, you answer. Be fair. You answer our question. Whether
But
3 years
if you
is
lords,
beneficial
if
or
that
2
is so,
years.
my lords, 3 years of service is beneficial. But the
Ah,
difficulty
yes,
would be,
ma'am.
but the difficulty
But
would be,
1/4 of his
1/4.
service.
Yes, sir.
1/4 will, my lords, of 7 years, 1/4.
Yes. So it is not even coming to 2 years.
That is the difficulty, my lords.
Shall not exceed 3
I'll not
years.
get 3 years, even if it is given, my lords, I'll not get 3 years.
beneficial and advantages to you.
Yes.
But the difficulty, that's the reason much I'm fighting for 7 years of service.
You are not entitled.
7 years you are not entitled.
No,
We
sir.
cannot rewrite the rules.
My lords, I'm not asking for rewriting the rules. My lords, language in TBS rules is shall be counted. Here may.
If
Language, there is a difference in language. The TBS rule says shall. That's what I tried to say, my lords, on the last occasion. The TBS rules which are placed on record,
government
This is a
servant
old
were to be
edition
applied to an aided institution, then that would be the
Lords, what happened, my lords, if I, maybe, my lords, I have to, my lords, make a submission because this issue has come up now. My lords, similar issue, my lords, had come up before the Karnataka State Administrative Tribunal, where, my lords, an employee who entered into government service, my lords, the issue of, my lords, the qualifying service, my lords, had come up. My lord, that issue, my lords, is decided by the Honorable KAT, my lords, saying that, my lord, the previous those rules are to those probably the qualifying service has to be taken into consideration for the reason that the government indicated before the KAT that they want to amend, my lords, the rules. My lords, if I'm permitted, my lords, I'll place that decision on record. My lord, your lords may consider, my lords, the same.
Let us not divert ourselves.
No,
sir,
no,
with
no.
this
No,
focus
no.
on
So
the
for a
case
government
content.
employee, a very similar case, similar arguments are advanced. The where the government had submitted earlier that they want to amend, my lords, the KCSRs, bring in conformity, my lords, with the other rules. The KT said they have to grant, my lord, they have to consider entire qualifying service, my lords. That's the reason said, my lords, there cannot be,
My lord, it is
any
true that
ambiguity.
it is
I'll
true
place
like-
it on record, my lords. Your lordships, my lords, can have this matter day after tomorrow.
My lord,
Tomorrow I'll
it
place
is
it
true.
on
My
record.
learned friend says the KAT is passed such an order. Then the state is came before this honorable court in writ petition. The order has been orders of the KAT has been quashed in writ petition number 11,208 of 2016. Your lord.
In my case only, my lords, recently the court has said, my learned friend, my
The
lords,
order has been quashed by this honorable court, my lord.
my lords, will place it on record, my lords.
That has been set aside, order
Yes, my
passed
lord.
by
It is,
the.
yes.
No, in fact, my
Orders
lords, I
passed
have,
by the KAT
till
has
date,
been
my
set
lords, I have
aside.
not, till date, my lords, I have not come across, my lords, that order.
Sir,
In fact, repeatedly, the orders are passed by the KAT.
Sir,
Even
please
recent,
note down. I'll give you the writ petition number. Writ petition number 11,208 of 2016.
Yes.
my lords,
Till
I'll,
the 13th December 2016.
So that order of the KT has been set aside,
Yes, my lord.
right?
State of Karnataka versus A.S. Ramappa.
my lords, I'll take a moment to go through, my lords, if I'm permitted. or can I make a request, my lords? I'll just go through this decision.
It's not requested. Now
No, your lordship have this matter, my lords, in the
240
morning itself. In the morning
It's
session
240
tomorrow, my
No,
lords.
sir, we will, sorry, we will not adjourn. If
Then, my lords, I would.
247 is
Then, my lords, I would.
applicable,
Then, my lords, I would only say, if your lordships kindly come to, my lords, the TBS rules, my lords.
now
The
we are looking
qualifying
at the
service.
Mr. Counsel, we are looking at the 247A as it stood
Please.
before 2012. It's not triple benefit, it's not there. Five is this military pension. Qualifying service is 10 years on the date of retirement of death. Then when the government by triple benefit scheme rules and service by recruitment, the provision of may be extended with advantages to the government servant in lieu of the period under Rule 245, 240. It is there, sir. It is there. So this
Six has become
five has become 6.
Lords, if I'm permitted,
Six
my
has
lords, the
become
order of
five.
learned single judge. My lords, the order of learned single judge, my lords, if I'm my lords permitted.
You can say that
Reads, my lords,
yes, 4 years. 8 years.
para 6 of the order of the learned single judge in my case, my lords, if I'm permitted.
Yes.
What the learned single judge holds is that, my lords, after extracting, my lords, Rule 248
Now
of
you
cases.
can say that 247, 6 during the relevant period as it stood, the rules as it
Can I
stood.
make a request, my lords? Can I make a request, my lords? Along with these representations, my lords, I'll make, my lords, the other. I'll include these aspects also. My lords, my case all along has been that, my lords, I was making a representation that my entire services are to be considered by the learned single judge, by the government, my lords, for as qualifying service. Learned single judge, my lords, has pointed out 248. My lords, now we are coming up, my lord, coming up with another provision. What I'll do, my lords, I'll make a detailed representation, my lords, again to the authorities concerned. Let them be directed to consider the same, my lords, in a time frame. My lords, if they can take a decision, my lords. If I am agreed, my lords, later on, my lords, I can agitate.
No submission is 248 is not applicable. 247A5 is applicable. We are saying 247A6 as it
My lords,
stood
still, my
just
lords, I'll be at, my lords, difficulty because 1/4 of the service, my lords, I'll be at loss. That's the reason, my lords, I'm trying to say if the government is, my lords, I'm,
No, this
my learned friend, my lords, pointed out to this.
kindly wait, sir. This writ petition 11208 of 2016. This is filed by the state of Karnataka.
Yes, my lord.
Alone.
It is state of Karnataka against A.S. Ramappa.
So the application made before the tribunal has been rejected.
Yes, my lord.
That has no bearing here. Say that either 247A, now you are submitting 247A5 is applicable. We will say that can be examined.
My lords,
Because
I'll
there
give
is
the,
specific-
my lords, the learned single, my lords, my only grievance before the court was that in spite of my lords representations being made, my lords, there is no consideration of the same. My lords, learned single judge, my lords, says under 248. My lords, I'll make a, my lords, representation. My lords, let the learned single judge, my lords, be directed to consider. My lords, the government be directed to consider My lords, within 2 weeks or 3 weeks, my lords, I'll take that order, my lords. If it is beneficial, my lords, I'll agree to that. I'm already aged 80 years, my lords, as of today. I cannot be, my lords, agitating, my lords, before the courts. Only with, my
When you
lords, some
got
hope that.
retired? When you got retired?
3110.
Retired
Please,
in the
Lord.
year 19.
31
Lords,
1999.
Please, my lords.
So please
It's already,
calculate
my lords,
whether
12 years, my
addition
lords, since I
available.
retired.
No,
And 80
addition
years
is
as
not
of now.
available. It is only in lieu of section 248. Not addition. It is in lieu of. Even the earlier rules also says it is in lieu of.
That's the reason, my lords, let there be direction, my lords,
Of the
to.
period admissible under rule 248, whichever is, if it is extended, if it is advantageous to the government servant in lieu of the period admissible under rule 48. The same phraseology is.
The learned single judge
They-
is rightly passed the orders, my
The
lord.
language, yes, the language is the same. No, which is most advantageous to you.
No, what I'll only see, my lords, if lordships kindly see, my lords, the order of learned single judge. I'll only say, my lords, my lords, the first portion, my lords, respondents, if your lordships kindly see page number 22, my lords, para 7. My lords, if the direction is only to consider the representation, my lord, instead of on relying on 248, my lords, I do not have, my lords, any grievance. Let them consider the representation and pass orders. My lords, there will not be, my lords, any difficulty, my lords, to the government to say that.
No,
My
sir,
lords,
you be clear. Now, just now you submit the 247A is
that is
applicable.
what I'm.
You be clear in your submissions, sir. Don't oscillate like this.
No, I am not oscillating, my lords. Why
Yeah,
I
whether
write was,
247.5 is applicable or 248 is applicable.
my lords, that's the reason, my lords, that should be, my lords, adjudicated, my lords, in the by the original authority.
You be clear about that point before us, sir. We will accept
sir?
it. We are agreeable. We are agreeable for 247.5 also.
My lords,
247.
if I put it, my lords, this way, my lords, what the difficulty, my lords, I am trying to point out. What happens is, my lords, the service of aided, the aided service of mine, my lords, was in different aided institutions. My lords, in that if the provision says in that institution, my lord, the question arises in which institution. My lord, that will be the other difficulty which I will be facing. Now, my lords, the TBS rules would say
Sir,
that also.
cannot expand the scope of this.
No, let me put, my lords, that if that provision is right, if your lordships kindly see the synopsis, my lords, which I have placed on record before your lordships. I have worked, my lords, in several institutions. My lords, from 1968 to 75. As my lords, page number 1 of my lords, my petition.
Can you find the synopsis?
Please, my lords.
When you have filed the synopsis?
Lords, in the synopsis in the appeal.
Along with the appeal synopsis.
Along with the appeal, my lord, it is.
Yes.
Lords, from 1968 to 75. Lords, I worked in, my lords, lecturer and reader in commerce at Mahavira College, Mudbidri, Dakshin Kannada, KGS Arts and Science College, Karwar, Uttar Kannada, and Dempo College of Commerce and Economics, Panaji, Govar. My lords, these are the institutions. Then, my lords, then I was selected by KPS.
That is why the appellant is entitled for the benefit under the 248 of CPC. KCSR, my lord. My lord, lordship, may I read the relevant portion of the writ petition order in writ petition number 11,208 of 2016, my lord, wherein this similar issue has been decided. Lordship, may kindly para number 2 of the judgment, my lord.
Another copy of this order.
May I read my?
By the way, sir.
Please. Sorry.
Okay, sir. Yes, kindly read it, sir.
Well, para number 2 of that said judgment, my lord. The short facts of the case appear to be that the respondent was appointed an assistant teacher in the school aided by the government in the year 1970. On 5/7/1973, resigned from the post of assistant teacher from the said school, as he was selected as headmaster in the government high school on 8/7/1973. He reported for duty as headmaster. On 9/7/1979, the state government passed an order for counting of the entire service rendered in the aided school taken over by the government as qualifying services. Rule 248 of KCSR provided for counting of only 1/4 of service rendered subject to maximum of 3 years. On 16/3/2001, the state government rejected the prayer of the respondent to count full service rendered in aided institution. The respondent preferred an appeal before the tribunal against the said decision. The tribunal, by the impugned order, allowed the application. Under the circumstances, the present petitioner is before this court. The state petition, my lord, this is. We have heard the so and so. The respondent is served, but none appears on behalf of the respondent. We may record that event an earlier point of time when notice was issued, none appeared for the respondent. A perusal of the impugned order passed by the tribunal shows that the tribunal has completely followed its earlier decision in the case of BK Nagaraj Rao versus State of Karnataka, and another in application number so and so decided on 22/6/2012 and has granted the relief on the same line of the respondent. Learned AGA so and so brought to the notice that the very decision of the tribunal in application number so and so was carried by the government before this court in writ petition number 39/359 of 2013, and the division bench of this court wide order dated 9/4/2014 has set aside the aforesaid decision of the tribunal and has allowed the writ petition, and the application made before this the tribunal was dismissed. Then the provisions has been quoted, my lord. At the para number 7, my lord, I'll skip the provisions and I'll go to the para number 7, my lord. Since there was no additional reasons recorded by the tribunal, and the tribunal has only recorded an earlier view taken in application number 4934 of 2003 dated 22/6/2012, and as the coordinate bench of this court has set aside the aforesaid view taken by the tribunal in application number so and so, the impugned order passed by the tribunal cannot be sustained. Hence, the same deserves to be set aside accordingly. So and so. Similar issue has been taken before the tribunal, my lord, learned Karnataka Administrative Tribunal, against which the state is came before this honorable court in writ, my lord. The orders of the KAT has been set aside, saying that they are not entitled for the entire length of service.
But he retired as a government servant, finally.
Yes, my lord. retired as a government servant. In this case also retired as a government servant.
Then how the writ petition is maintainable?
Lord's, adding
This is
of
also a
those
question. This
service.
is also a question. Once he is retired as a government servant, he has to go before the Honorable Karnataka
Lord's,
Administrative Tribunal.
Lord's, it
For
is in
section
relation
19
to
of
Lord's,
the
my
CH-3 Act.
appointment in an aided institution,
Yes.
not
It is
in, in relation to government institution.
What
In relation to an
retired as-
aided institution, computing qualifying services
But
in the
you
aided
retired,
institution.
but you retired as a government servant.
My lord, that is not the criteria, my lord. Say, if your lordships permit, section 19 of my lords, the Administrative Tribunals Act.
Definition of service, 2 years.
Now, because in the other matters, the petitioners therein had approached the tribunal. Against the
Yes.
tribunal order, they were before this court. That is not so here. Directly you filed the writ petition.
Lords, in
Yes.
my case, in this case, my lords, it was only my lords concerning the appointment in my lords.
The facts are very similar, sir. The facts are very
Facts are
similar.
very similar, my lord.
Here
Facts are very
also.
similar. No
Yes,
doubt in
in
that.
this,
That's so similar.
in Ramappa case, yes, he was appointed as an assistant teacher in the school aided by the government in the
Yes.
year 1970. Here also the same thing. Yes, you have worked in different
Institutions.
institutions which was aided by the government. And so finally you have now been recruited through as a government servant through joining government service in the year 1975.
1975.
Subject matter is not aided service. Subject matter is counting of earlier aided service for purpose of
Qualifying
pension.
service.
Pension.
Yes, whether qualifying, what is the
Subject matter
qualifying
is pension.
service? Qualifying service to determine the pension is the question here.
Then, my
What
lords,
is the qualifying service that has to be considered?
even on that count, my lords, the order of Learned Single Judge has to go.
Huh?
Now you have
Even on
suffered.
that count, my lord, the order of Learned Single Judge has to go. My lord, is my.
No, has to go. No.
I'm my lords, ultimately, my lords agreed by limiting the consideration under 248. If the government takes any decision, my lords, my lords, tomorrow next day, my lords, I can approach the KT
No,
itself.
we can say 247.5. We can say, as you submitted, we can say 247.6 as it stood then. If it is
Lord,
not 248.
I'll
That
make
is
one
again,
request,
it is
lords.
not in addition, it is in
I'll-
lieu of.
I'll make only one request, my lords. Your lordship may have this matter tomorrow, my lords. I'll seek instructions and make submissions, my lords.
What for? What remains?
My lords, whether he is willing to take, my lords, or still wants to, my lords, contain it, it should be, my lords, left to the, tomorrow morning itself, my
No
lords.
further arguments, sir. We will make it very clear. No further arguments.
No arguments, my lords. I'll only make a submission, my lords, before the court. Whether he is ready to be willing to take, or my lords, or any decision, my lords, of the court, I'll take.
Willing to take means what with willing to take?
My lords, whether he is willing to take, my lords, under 245, 247 5, my lords,
Yes,
or,
that is
my
your
lords,
submission. We are agreeable for that.
my lords, I'll take
You
instructions
made
and.
that submission. You made
Lord,
that submission.
No. I only pointed out to say that the order of the Learned Single Judge directing consideration only under 248 is not
Whether-
correct.
No, whether, because you made the submission, we are agreeable.
Correct,
for
my
that.
lords. I don't dispute. But what I tried to say was that he could not have restricted consideration under 248. If the order of Learned Single Judge is seen, if the Learned Single Judge
So we will
directs,
say, even let the authorities keep in mind 247A5 also, along with 248.
Yes,
Both
yes.
are interconnected. It need not be independent of that. In lieu of 248. Yes, we'll say so. Why should we adjourn the matter?
can I make one? If then, my lords, I'll make only one request, my lords. If your lordships kindly see, my lords, the order portion. Para 7, my lords. Lords, it says, Lords, respond number 1 and 2 are directed to consider the representation of the petitioner with annexure B to E, dated so and so respectively. Lords, instead of, my lords, in the light of.
That is right.
Your lords may,
actually.
your lordship may say including. So that, my lords, I can,
Not including.
they are free to say, my lords,
Either this or that. Either this or that.
Are they including anta? That's
No,
what I, instead of,
including
what happens, my lords, in the light of, my lords, they will say, my lords, both will not come and will reject.
We say,
Some
we
lords
will
at
say
least
in the light of Rule 248 or 247,
Yes,
6.
yes, yes.
Instead of, my lords, in
That
the
can
light
be
of, my
done.
lords, including. That's what I'm
47
trying to.
A6.
Whichever is advantage.
A6.
Alla,
Whichever is
instead ಬದಲು
advantageous.
including ಅಂತ
correct.
ಹೇಳ್ಬಿಡಿ ಅಂತ ಅಷ್ಟೇ ನಾನು. That's what I'm trying to request.
No. Either 247 A6 as a student or 248,
248.
whichever is more advantageous.
To the
My lords, only request, my lords, is that including ಅಂತ ಬರ್ಲಿ ಅಂತ. ಯಾಕಂದ್ರೆ
no,
tomorrow I can put it across, my lords, some other thing also, my lords. That's why.
oh my lord, once it becomes ಆಮೇಲೆ ತಿರ್ಗಿ
ಏನಾಗೋದಿಲ್ಲ including ಅಂತ ನನಗೆ court indication ಮೇಲ್ಗಡೆ.
it cannot
Lord, the observation of this court,
There
my lords,
is
in
no-
para 6 remains intact.
You know very well how the word phrase including could be interpreted. It expands.
My lords, para 6, there is already an observation. My lords, I'm not saying anything about observation in para 6. Only the direction portion, my lords, I'm seeking for, my lords, different word, my lords, are to be incorporated.
That will have a cascading effect. Including means, you know very well, sir,
Yes.
it expands. It
it
extends.
expands. My lord, my friend is seeking 3 years plus 2 years, 5 years.
Yes.
If
ಇಲ್ಲ ಆಗುದಿಲ್ಲ. It was right now.
includes that happens.
In lieu ಅಂತ ಇರೋದ್ರಿಂದ ultimately it is for them to take a call ಅಂತ ಅಷ್ಟೇ. That's all. That's why I said so.
Your claim is 9 years.
7 years, my lord.
9 years.
7.
68 to 75.
9 years, 2 months.
I'm sorry, my lord, that is not correct. 68 to 75.
In your writ petition, what is the prior sorting?
My lords, it's actually, my lords, he joined, my lord, the service in 68. One that is on 1/7/1968. My lords, 11 years, my lords, is not correct. 7 years, my lords.
So kindly read your prior in the writ petition, sir.
I understand, my lord, there is a.
Of the pensionable service of 9 years and 2 months that the petitioner has rendered at the
You-
private aided degree college.
That is not correct, my lords. Your lordships can see, my lords, from 1/7/1968 to 7/11/1975 date is given. So date ಕೊಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ 7 years ಬದಲು 9 years ಅಂತ ಆಗೋಗಿದೆ ಅಷ್ಟೇ. 7 years. But there is a mistake in the
That
prayer,
has
my
been
lords.
followed by the learned single judge. How can you find fault with the court?
No, I'm not finding fault with. Kindly read the prayer, my lords. If I'm permitted, my lords, I'll take your lordships through the prayer. Issue writ in the nature of mandamus, directing the respondents to reckon and count the pensionable service of 9 years and 2 months that the petitioner has rendered at the private aided grantinate degree college and other educational institutions as a lecturer and reader in commerce from 1/7/1968 to 7/11/1975. That is the only 7 years, my lords, not 9 years. Date, my lord, he has specifically said.
Put it as 9 years.
Lord, there is a mistake, my lord, typographical error that has come up.
Typographical error. So it is 7 years, 2 months, huh?
7 years. 7 years, 4 months ಬರುತ್ತೆ. 1/7 ಇಂದ 7/11 ವರೆಗೂ 1 year, 7 years, 4 months ಬರುತ್ತೆ. And 6 days.
This intra-court appeal is directed against the order dated 30th July 2021. And a single judge in writ petition number 5085845 of 2018, whereby the writ petition filed by the appellant hearing disposed of, directing the respondent numbers 1 and 2 to consider the representations of the appellant in the light of Rule 48 of Karnataka Civil Service Rules in brackets KCSR and pass appropriate orders in accordance with law within a time frame of 3 months from the date of the receipt of the copy of the order. Appellant to be the lecturer and reader in commerce having served at Mahavira College, Modabidri, Dakshina Kannada, semicolon, KGS Arts and Science College, Karwar, and SS Dempo College of Commerce and Economics at Panaji, Goa, between 1/7/1968 to 7/11/1975. For Edict of Mandamus to reckon and count the qualifying service for the purpose of pension at 7 years, 4 months. As a lecturer and reader, and to settle all retirement benefits. Learn a single judge. I mean, consider Rule 248 of KCSR has directed the respondents 1 and 2 to consider the representations of the petitioner in the light of this, in the light of Rule 248 appropriate orders in accordance with law. Being agreed by the said order of the learned single judge, particularly the direction issued to the responding numbers 1 and 2 to consider the representations in the light of Rule 248 of KCSR, inverted comma salakal, in the light of Rule 248 of KCSR. The appellant is before this court. Learned counsel for the appellant are the underline in the light of this learned counsel for the appellant. I would submit that the relevant provisions which would govern the case on hand was in as qualifying service for reckoning pension was neither answered by the respondents nor argued before the court. However, the writ court proceeded to pass the order referring to Rule 248 of KCSR, which would be applicable to the triple benefits scheme rules, which heavy reliance was placed by the appellant. Referring to the provisions of the triple benefit scheme rule, in computing the length of qualifying service, all previous service, whether temporary, officiating or permanent in regular and whole-time posts in any state, aided institution or institutions governed by the Karnataka State Triple Benefit Scheme rules, shall be taken into account provided the services of employees in such institutions or regulate service with the necessary approval of the county. The grant was allowed thereof by the department concerned during the period, in respect of the institution. It is extracted here, but it can extract. Heavy reliance on this Rule 80 of the triple benefit rules. Learned Counsel argued that for 248 of KCSR would not be applicable. Or in other words, it cannot be, or in other words, the pension and gratuity benefits could not be limited. The period as mentioned in Rule 248. That the attention of the court was drawn to Rule 247A6 of the KCSR as it stood then. Submit that the government servant ceases to be governed by triple benefit scheme rules. Service by provisions of Rule 1 of 247A may be extended if it is advantageous to the government servant in lieu of the period admissible under. If it is advantageous to the government servant, full stop. Thus, the learned counsel seeks to modify the order of the learned single judge. Presentation of the petitioner in accordance with law without referring to Rule 248 of KCSR. Learned AGA appearing for the respondents. You are appearing for all the respondents, sir?
Both the respondents, ma'am.
Yes.
Both.
Submit. Both submit that. For 248 of KCSR movie relevant in the facts of the case. Which deals with an employee of an educational institution which is recognized by government, gets into government service. In regard to this provision, a single judge has rightly passed the order into the same just to be confirmed by this court. If learned counsel submitted that in the case of state of Karnataka versus Sri A.S. Ramappa in the petition number 11208 of 2006. In identical circumstances, the order of the tribunal challenge therein was rejected, allowing the petition filed by the state. The coordinate bench, this court, categorically observed that Rule 248 of KCSR provided for counting of only 1/4 of service rendered in aided school taken over by the government as qualifying service would be applicable to maximum of 3 years. We have carefully considered the various submissions of the learned counsel appearing for the parties and produced the material on record. As aforesaid, the controversy rests upon the applicability of Rule 248 of KCSR to the facts of the present case. In the background of people benefit scheme rules, the undisputed facts of appellant, the various aided and private colleges between 1/7/1968 to 7/11/1975. On 8/11/1975, he was selected by the KPSC and joined government service as Class 1 Gazetted Officer at Government University College, Arsikere. On attaining the age of superannuation, but on 31/10/1999. The Rule 18 of the triple benefit scheme rules dealing with the qualifying service refers to the qualifying service that requires to be considered. See? Today, Rule 248 of KCSR, which reads thus, extract matter. Similarly, Rule 248 as it relevant period relevancy in the matter. The said rule here under for ready reference. A harmonious reading of these rules would make it clear but the government's employee has served under the various aided and private institutions on joining on entering the government service by recruitment. Generally, even has entered if despite the government employee who is governed by the aided has been governed by the triple benefit scheme rules. But when enters government service by recruitment, comma, the rules as per 47(1) would be applicable in lieu of period admissible 248. It's more advantageous. Means again. In the background of these rules, we may clarify that the representations of the petitioner of the appellant to be considered by the respondents in the light of rule 248 read with 247A plus 6 as it stood during the relevant point of time. Thus, the arguments of the learned counsel for the appellant that both the rules could be made applicable that is 247A 6 has to be applicable in addition to 248. Rule for 248 is wholly misconceived and stands negated. It's we pass the following order. Appeal is allowed in part. The order the single judge dated 30th July 2021 passed in writ petition number 50845 of 2018 is modified, directing the responding numbers 1 and 2 to consider the representations of the appellant by the annexed B to E dated 1/8/1988, 8/6/1999, 26/8/2000 and 10/1/2001 respectively, in the light of Rule 248 read with 247(6) of the KCSR and pass appropriate orders in accordance with law within a period of 3 months from the date of the receipt of the copy of this order. With aforesaid observations and directions, it stands disposed of. And 247 or 247A and A or 248, whichever is advantageous. Today. This is also 45. The coordinates of Casting petition number 11208 of 2016, that is the 13th December 2016.
Manish,
I appear for the first respondent.
Manish,
Yes, what is the matter? Mahesha, even in the first round, there was no representation.
It was passed over. Under the petitioner was working as bill collector, and he was dismissed from service. Thereafter, the appeal was filed before the Jilla Panchayat. The said appeal was allowed. Since that was not implemented, I had approached this report. This report passed the
This
directed
appeal is filed by the Gram Panchayat.
Gram Panchayat. So restatement the back ways order ಮಾಡಿದ್ರು. Against which the Gram Panchayat has filed this appeal.
And the last occasion, there was no representation.
Yes, the last time.
Yes, for the appellant. Counsel for the respondent number 1. 2 is also present, Mr. Ashok Nayak.
ಅಶೋಕ್ ಅವ್ರ ಹೊರಗಿರ್ಬೇಕು ಮೇಡಮ್
Physically.
ಅವ್ರದ್ದೇನಿಲ್ಲಪ್ಪ ಓನ್ಲಿ ಗ್ರಾಮ
Counsel-
ಪಂಚಾಯತ್
Yes, learned
Hello,
counsel
one-
for the respondent. Yes, what is your submission, madam? You are not, what is your submission? Yes, learned counsel for the respondents are present. We'll give, we will adjourn and we'll see on the next date of hearing, if there is no representation, then we can dismiss that.
Yes.
appeal. Even on the last date of hearing, there was no representation. Sir, any contempt is pending.
ಇಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ಇಲ್ಲ
ಎಷ್ಟು ಮಾತು ಫೆಬ್ರವರಿ
ಡೇಟ್ ಮೇಡಮ್
15th February, next week, sir.
ಹುಬ್ಳಿ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 23 ಏನಾಗಿದೆ ಮೇಡಮ್ 23 ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ವೀಕಾ 23
ರಿಜೆಕ್ಟೆಡ್
ಅಯ್ಯ ರಿಜೆಕ್ಟೆಡ್ ಓಕೆ ಮೇಡಮ್
ಬರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ
ಸರಿ ಮೇಡಮ್
ಅಂದ್ರೆ ನಿಮ್ ಸಾಹೇಬ್ರು ಅದು 247A 247 ಸಾಹೇಬ್ರು